about the availability of an audio?
I did not.
Okay, do that. I'm going to grant it.
Okay.
And that's for the preliminary exam.
Correct.
Got it.
So we have the warrant transcript, the arraignment, the lower court arraignment on the information transcript. We have the pre-exam transcript. We have the audio from the preliminary exam transcript.
Right.
And as far as that is concerned, that's what the defense is requesting.
Okay, you can move on to the next motion.
Okay, the defense motion to strike general information. Your Honor, essentially the people information has been modified probably 3 or 4 times in this case. The lower court warrant was sworn to certain facts from Detective Palmer, and he swore that I did assault, batter, wound, those 6 words, and assault to resist instructing Officer Thurmond. That defect carried through the arraignment and the preliminary exam, and it was never cured on the record. So the defect was not only harmless error, it was futile because it deprived the defense of right to confront the only complaining witness that was stated at that point in time. I understand that the people don't have to present every single witness, but when you have the actual complainant and the complaining witness, then those are changed. Then when we get in circuit court subsequent to the bond over, you amend your complaint and take out the only complainant that was on the original warrant is futile.
I got it.
Because the reason that they did it was to gain a tactical advantage, because at that time Sergeant L. Porter was under federal scrutiny for federal complaints for shooting unarmed African Americans.
Okay.
And they did that as a placeholder, then switched it up at the preliminary exam, then withheld the dash cam video, which was already in evidence, and that's evident because the prosecutor letter to Detective Shadwell, I believe, he asked for the dash cam that was already in evidence, quotations.
Okay.
So my right to due process has already been violated. I'm simply asking for remedy, and the remedy in this case should be a remand back to district court. Your Honor, if you look at the complaint de novo, count 1 is under the motor vehicle code. It's a gross misdemeanor. Your Honor, the basic elements to any traffic offense, you must identify the vehicle, identify the driver, and establish jurisdiction upon which public highway offense occurred upon, because count 1 is governed under the motor vehicle code. So that's engaged in commerce. So criminal procedures was not initiated at the scene, and the prosecutor failed to issue a request of summons. I never received a summons on the warrant. And the complaint is not in accordance with MCR 6.101, 102, 103, or 104. The defect is futile. The complaint is not proper. This court lacks subject matter jurisdiction because this incident happened in Detroit. Now, say for instance, let's play devil advocate that the 100-ride rule apply. That an officer have 1 mile radius to go into another jurisdiction. Well, that's cut off because the only reasonable suspicious that was stated was for to investigate felonious assault. Well, that violates Arizona versus Johnson, because you can only detain a vehicle when it's a vehicle infraction parallel to your investigation. Then they violated Arizona versus Gant because the property was taken in absence of a custodial arrest. There was no warrant requested. That was stipulated at the preliminary exam. So you have all these defects, and the fruits from the seizure is poisoned, and the testimony, the fruits of the testimony is poisoned and perjured because the dash cam video directly impeaches all witnesses in this matter, from the audio dispatch communications to the dispatch communications to the police report. I asked this prosecutor for an unredacted police report. He sends me a 2-page. The police report went from 17 pages to 2 pages, and he only lists Officer Smith. They keep jangling the victims and the complainant and the lead witnesses. First, the lead officer in charge was Detective Palmer. Then it was Detective Shadwell. Then it was Officer Thurmond. Then it was Sergeant L. Porter. Now it's Officer Smith. I predict at the evidentiary hearing, Sergeant L. Porter would not show up because he don't want to get impeached. So they would use Officer Smith for count 1 and just use Sergeant L. Porter preliminary exam testimony to fill in the gap, hoping that this court will send this thing on to trial. Now, I don't know if this court has seen the dash cam video. I have attached it to plenty of my pleadings, whether it's irrelevant or admissible or before the court. the court must satisfy justice, and justice must satisfy the appearance of justice. And if anybody with a reasonable mind look at that dash cam video de novo, just use your common sense, Your Honor. How can you be charged with assault, resisting, and obstructing if you're never arrested? You cannot retroactive a charge 6 months later after a citizen's complaint been filed, after the defendant had to go to the hospital, after DPD conducted a 90-day investigation and came back by the preponderance of the evidence on my side. This equals up to prosecutor misconduct because the prosecutor is intentionally using perjured testimony as a factual basis. Not one time did he reference the dash cam video. If it was up to him, they would have destroyed the dash cam video along with the K9 report and the Northland Mall video. Now, I used to do security, and I'm an expert on certain technical things. There's no way the mall video should have been missing. If it was an investigation for felonious assault, that evidence should have been preserved. The K9 report, it was a search incident to a K9 search. If you're using the smell doctrine as probable cause to search the vehicle, where's the K9 report and the scientific data to back up that theory? I don't even know the hypotheses in this matter, Your Honor. I don't even think he has one because it's erroneous. The charges is erroneous on his face, and I'm just asking this court to look at the evidence. I don't want to have to keep removing this case to federal court and create conflict of interest. I just want the truth. It's only a certain amount of time before the chickens come home to roost. And with the poison, with the perjury, it's just going to be collateral damage. We already have one judge disqualified in this case. We already have Judge Richards that ruled that Magistrate Posey abused her discretion on bond because I would have never been locked up. The Southfield PD never requested a felony charge in this case. Then it was verified at the scene that felonious assault didn't occur. So I remain the balance of my time for rebuttal.
There's a couple other motions I thought you had.
Oh, yes. I'm sorry, Your Honor. I just have, I have a response to the people motion in limine. But let's see what the other motion I had. I'm sorry. I have to waive fees. I have to, the compel exculpatory evidence. Okay, yes, Your Honor. This is not merely discovery I'm talking about. This is exculpatory evidence. The Northland Mall video, the K9 report. Until I get an affidavit from the searcher or researcher that claims this doesn't exist, it cannot be refuted on the record that it don't exist. I'm asking for my camera that I had, the T4i, which the people even admit does not have any evidentiary purposes, but yet they took it. Doesn't make any sense. I want my camera with my SIM cards because I recorded the events from the mall in absence of the Northland Mall video missing. I need an unredacted police report because I might use that as a business document to impeach the witnesses. I don't know. But it's a lot of things that's redacted in the original report. I want 01, 002, 003, 004, 005, 006, 007, 008, and 009. The police report itself has been modified in this case. Your Honor, the verified offense on a police report on November 19, 2013 was suspicious circumstances. Now all of a sudden it's been modified to felonious assault. You get what I'm saying? It's a lot of trickery going on and fabrication. They're trying to establish probable cause. There was one more thing, Your Honor. Your Honor, that's it for us, that motion.
You have another one to take judicial notice of lack
No,
of...
I'm sorry, Your Honor. I want to strike those two precipices. I think I had a precipice to take judicial notice.
Okay. Gotcha.
And a motion to... It was 5 motions altogether. I only presented 3.